Delegate Levine has House Bill 2082.
Thank you, Mr. Chairman and members of the committee. House Bill 2082 adds transparency to the redistricting process. It requires meetings and hearings of the Virginia Redistricting Commission to be live streamed, whether held virtually or in person, and to allow for public comment. Meetings and hearings can be held virtually, but if they're held in person, they're required to be held in different regions of the Commonwealth. An additional public hearing is required in the event that the General Assembly rejects the initial maps. And the public gets to know where the maps are because any adjustments made are made on the website. So the public is abreast of everything that's going on. The bill also requires that in the event the Supreme Court of Virginia is called upon as a backstop, that their meetings and hearings are also open to the public. And the reason for that, frankly, is that it's quite easy to send this to the Supreme Court. Only 2 delegates or 2 senators can do so. 2 can actually overrule 14 on the commission. And so the thought is that if we require the Supreme Court of Virginia to, when acting as a backstop commission, to have the same restrictions the commission has, it's less likely people will play games with it. So the commission does not allow ex-parte communications, does not allow you to secretly meet with someone and draw the maps. This would prevent the Supreme Court from doing that as well. It says all meetings are public, Supreme Court meetings are public as well. Now, under current law, there is a Democratic and Republican special master appointed if the backstop of the Supreme Court is used. And those special masters could meet in private and help draw the maps. They'd have to. They don't work a lot of time together. But the idea is, like with the commission, that the Supreme Court relies on their joint work that comes out. And they may have several maps. The Supreme Court still establishes a district, but each of these districts are approved by both sides to ensure a fair process. And my hope is that with a very fair process before the Supreme Court, it'll never be used. That if we see that the Supreme Court is fair with all the restrictions the commission has, folks will say, well, we don't need this backstop. We'll just use our original commission. So with that, Mr. Chairman, members of the committee, I'm happy to answer any questions.
Are there questions for Delegate Levine?
Yeah, Mr. Chair.
Senator Eben.
I'm concerned on lines 87 through 90 about all communications being in a public hearing. Does this mean that the special masters can't contact a local electoral board about precinct lines or about the number of people that are registered outside of a public hearing?
So it says, and this, by the way, is the exact same language it's used for the commission. It copies that language. It says the court, the special masters, and DLS, and any advisor or consultant shall not communicate with any other persons about matters relating to the establishment of districts. So the way I read this, and again, if you have an amendment to make it better, is that Division of Legislative Services could certainly, any other shall not communicate. I guess they would have to have a public meeting or hearing. I would say this, though, the commission also has to have a public meeting or hearing. That's current law. So I simply copied the language from the current law for the commission. So again, if you'd want them to be able to contact a registrar, I would certainly be happy to have that as an exception.
Senator Eben, did that answer your question?
I think so.
Okay, are there additional questions? Are there those in the public who want to speak to this bill?
Mr. Chairman, if I could ask a quick question.
Senator Bell's got a question. I apologize. Senator Bell. Delegate Levine, you still there?
I'm still here.
Thank you, Mr. Chairman. Delegate Levine, I know you spoke with me about this, but question that came into my mind, does this add to the timeline of what you're doing with the advertisements, public notices, and the other recording issues?
I don't think it adds much. The live stream happens anyway. It doesn't add any additional public meetings except one, and that is if it's rejected. It does add one public meeting if it's rejected. Otherwise, the timelines are the same.
Delegate Senator Bell, did that answer your question?
Thank you, Mr. Chairman.
Yeah, are there additional questions of Delegate Levine? Are there those in the public who would like to speak?
Yes, Mr. Chair. We
have a bunch?
I'm sorry, Mr. Chair.
Do we have a bunch?
I see 4 hands.
Okay, 4 hands.
Yeah. Aaron Corbett, please go ahead.
Thank you, Mr. Chairman and members of the committee. My name is Erin Corbett, and I am the Redistricting Coordinator for the Virginia Civic Engagement Table. We believe the newly developed Redistricting Commission should work to be accessible and transparent in all of its meetings, decisions, and communications. By codifying language access and meeting transparency, House Bill 2082 helps ensure this. On behalf of VSET, we ask the committee to vote in support of this legislation. Thank
Okay,
you.
Thank you very much. Who's next?
Marianne Burke, please go ahead.
Ms. Burke?
Yes, thank you. I'm Mary Ann Burke from the Virginia Grassroots Coalition. I ask that you please vote for this bill. A goal of Amendment 1 was to create a system that was transparent to voters and watchdogs. This bill will bolster the transparency of the Redistricting Commission, prohibit off-the-record negotiations, and ensure that Virginians have adequate opportunities to attend hearings on how the maps were drawn. This legislation will not hurt or delay the Commission's work in any way, but instead it will help make better maps for Virginia. So I hope to see that you can report this bill.
Okay, thank you very much. I understand a few more people have raised their hands, so I'd ask you to limit your comments to 30 seconds each.
Mr. Chair, we're having technical difficulties. It'll just be a minute.
I'm not, did you just call Megan Ryan? Megan Ryan with the Virginia Coalition for Open Government. We advocate on behalf of everyday citizens who want to hold their government accountable, and we support this bill.
Okay, thank you very much. Who's next?
I could go next. The Virginia State Conference, NAACP, supports this bill for transparency and public trust. I think it'll help with public trust, but I do think that Senator Evans' comments should be taken into consideration.
Thank you very much, Ms. Quinnoy. Who's next?
Lisa Stabe, please go ahead.
Yes, ma'am.
Lisa Stabe, please go ahead.
Lisa Stibe, Virginia Education Association. We're in support of this bill. Thank you.
Okay, thank you very much. Are there others?
Yes, Mr. Chair. We have Edward Macon. Please go ahead.
I think he's from the Supreme Court, and he's probably got some views, but he's probably just here to answer questions. Is that correct?
Yeah, that is, I'm happy to answer questions. We do not have a position on the bill. We had two concerns based on our staff review that potentially raise constitutional questions.
Well,
One,
I was wondering, I was going to ask you, Mr. Macon, on line 59, all meetings and hearings of the court regarding the establishment of districts shall be open to the public. I mean, does the legislature tell the court how to hold meetings otherwise?
Mr. Chairman, I think that does raise a separation of powers issues. As you know, courts have oral hearings, they have oral argument in the case of the Supreme Court, and then the decision is made, it's published in writing for everybody to see, but the deliberations of the court are never open to the public. And so that's the concern with that provision.
Well, my other question was on line 69. It says, any plan submitted to the court shall be affirmed by both special masters to be a product of their cooperation and their collaboration, and only a plan so affirmed may be adopted by the court. Doesn't that language undermine the constitutional amendment altogether?
I thought, Mr. Chairman, I think it might. The constitutional amendment says in 3 different places, if this comes to the court, and I would hope it doesn't get that far, but if it does, then the districts would be established by the court. I would just note one other, the existing law, which you see at subsection F of 30-399, says the court appoints 2 special masters to assist the court in the establishment of districts. As I read the new language at line 69 to 71, that would have the court assisting the special masters, or the court would veto or could only accept or veto whatever the special masters come up with. So we did have a question about that. But those are the only concerns.
Those are the concerns I flagged when I read the bill.
Mr. Chairman,
Senator Spruill.
you asked those questions, but was there a concern that he had? You asked the question yourself, but Okay, are they the same questions that you had?
Yeah.
Okay, thank you.
But just from the Supreme Court, he was just there. If anybody else has questions, you ought to ask them.
Thank you.
Okay, is there anybody else in the public who needs to speak?
Yes, Mr. Chair, we have Joanne Collins, and just a reminder, if you'd like to speak, to please raise your hand.
Ms. Collins?
Good afternoon. My name is Joanne Collins. I'm with Herndon Reston Indivisible, and we are in support of this bill.
Okay, thank you. Thank you very much.
Mr. Chair, our final speaker is Mary Detweiler.
Ms. Detweiler?
Yes, hello. Can you hear me?
Yes, ma'am.
Hi, I'm Mary Detweiler. I'm a resident of Arlington, Virginia, and I am strongly in favor of this bill. I believe that now, during the time when there is so much distrust nationwide and in Virginia about our election institutions, this bill could not be more timely. So I strongly oppose it and hope the committee will pass it. Thank you.
Okay, thank you very much, ma'am.
Mr. Chair,
Senator McClellan?
I have a question that I'm not sure if it's for the patron or for Legislative Services Council.
Brooks is on the line, so Brooks, pay attention. Senator McClellan's got a question you or Delegate Levine might have the answer to.
So as I read lines 87 to 90, Section H, dealing with prohibiting the court, the special master, and any DLS staff, et cetera, to talk to anyone about matters related to the establishments and districts. If the legislative districts end up challenged in federal court under the Voting Rights Act, which, as we all know, has happened before, as I read this section, it would prohibit any of these entities or individuals from talking with, either leading up to or as a part of that case, any lawyers to determine, whether they're in discovery or anything around that case. And I guess this is for Brooks. Is that an accurate reading of those lines, and can we do that?
Mr. Chairman, Senator McClellan, that's a potential reading of that. I would agree. It is related to wording related to the establishment of districts pursuant to this section. How one interprets that is that you can't talk about the establishment of districts insofar as they're about that content, or is it you can't talk about districts just in that context, if that makes sense, that distinction. So, that would be the decision a court would be making if this came up. And
Mr. Chairman, I think I can respond a bit further,
okay,
if I may.
You sure may.
Thank you, Mr. Chairman. Lines 87 to 90 are a direct copy of current law, which is section 3392G. And this part isn't changed by my bill, but 3392G says, this is a direct quote, commissioners, staff of the commission, and any other advisor or consultant to the commission shall not communicate with any person outside the commission about matters related to reapportionment or redistricting outside of a public meeting or hearing. So that's current law. And if that's a flaw, and it may well be a flaw that Senator McClellan has exposed, that's a flaw of current law as well. What I've done in merely copying that language is said the same language that applies to the commission also applies to the Supreme Court. That being said, I'd be happy to make clear, I read it as in the establishment of districts, meaning while they're establishing the districts, they can't communicate. But a court hearing happens long after the establishment of the districts. It's about ruling on whether the districts are good or not. They're not actually establishing it while there is a court hearing later on about whether they're fair or not. So my reading of it was, no, it's only the establishment. But again, I copied it from 3392G, which is unchanged. And actually, that's my same response to Senator Eben, that it's exactly that same language. And maybe if it needs to be tightened up, I take it by, we could get an amendment to tighten it up to make clear, because certainly my intent was only during the establishment of the districts. And frankly, we could tighten up current law too, because even if this bill dies, we still have the same exact language problem in current law 3392G with respect to the commission.
Senator McClellan, did that answer your question?
It does, Mr. Chair, and I think it is worth making that clarification in both current law and in the new section, because as someone who was deposed and ended up being a witness in 2 federal court trials on the redistricting cases, I think that's why that jumped out at me, and I don't remember being present for the hearing on the current law, or I would have mentioned it then.
Okay, Senator Sproul.
Mr. Chairman, 2 things. The first one, that I got my new hearing aid in, and someone north on that side of the aisle, they could kind of chill a little bit so I could hear they're talking too loud on that side of the aisle.
Okay, you hear that?
They're both Democrats and Republicans.
Calm down over there.
Okay. Thank you, Mr. Chairman. Next question. Mr. Chairman, my concern was the gentleman from the Supreme Court. I might be saying it wrong. Yes, how are we going to fix those 2? I'm supporting the bill, but I want to know how can we fix those 2 concerns that he has.
I think
May I address that, Mr. Chairman?
you can or I can. I mean, we probably have different answers.
We may well have different answers. You want to go first, and I'll go second?
I'd rather hear the chairman.
I think that the problems identified by the Supreme Court are fatal to this bill.
All right.
I mean, honestly. But Delegate Levine probably has a different view.
I do have a different view. So, Mr. Chairman, in hundreds of years of Virginia history, the Supreme Court has only acted heretofore as a court under Article 6 of the Constitution, hearing judicial matters with a plaintiff and a defendant, in re, with papers, briefs, all of that. And none of that is disturbed by this. In this, and the only time in the whole Constitution of Virginia, the Supreme Court is not acting under the judiciary branch, Article 6. It's actually acting under Article 2. And it says basically the Supreme Court is a backup commission. There's this commission, and if 2 people of the commission don't want it, the Supreme Court's the backup commission. They are establishing the districts. They are acting as politically as the commission is. And that's a new role for the Supreme Court, frankly, and maybe one they didn't welcome, but it's in our Constitution, and that's where we are. So it strikes me that saying that when the Supreme Court is acting in its capacity as a commission, not acting as a court, not if it's ruling on the law, it could still do its deliberations. But when it's politically choosing among maps, then it's exactly doing the exact same content the commission is doing. And in that narrow capacity, it should be open to the public. And it's not a separation of powers issues because the Supreme Court is acting as a commission, not acting as a court.
Thank you,
and
sir.
That's why I think it's actually perfectly constitutional.
Senator Evans got something.
Yeah, I just wanted to ask, the bill seems a little bit prescriptive in that it's requiring certain numbers of hearings to be held by the commission before they finalize their plans, 3 public hearings in one case or 1 hearing for if they had to redo the plan. And it says shall hold at least 3 public hearings in one portion, but then it says meetings and hearings that are held in person shall be conducted in different regions of the Commonwealth, including the Northern Virginia region, the Central Virginia region, the Hampton Roads region, the Southside region, and the Southwest region. So when you say they have to hold 3 public hearings, but they have to hold them, do they have to hold them in all 5 regions?
No, the way I see it, Senator Evan, is that first of all, they can have them all virtually. But to the extent that they're held in person, there shouldn't be 2 in the same region.
So they can't hold 2 in Richmond. You want to specify that?
Well, they could, I guess, if they went to all 5 and had 6 of them, they could. But the 3 public hearings are part of the constitutional amendment. That's actually not anything I've added. The only thing I've added is the 1 public hearing if it's rejected.
There's new language on line 28 that says shall hold at least 3 public hearings in order to receive and consider comments from the public after prior to voting.
Right. That's if you look at the original language, that's in C 21 to 24.
Okay. Delegate Levine, I'm correct that these sections you're amending have just been the law since November of this past year.
That's correct.
Okay. So, okay. Are there additional questions from the committee? Are there additional people that from the public who need to speak? We've already heard everybody?
Yes, Mr. Chair.
Okay.
Last thing I'd say, Mr. Chairman, is if Senator McClellan would like me to try to fix her section and work with her on it, I'd be more than happy to take it by and work on that and really tighten up
Well,
both the bill and
Delegate
current
Levine,
law.
Don't do that.
this is the last meeting, this is the only meeting
Oh,
we're
it
going to
is?
have. So what I'd
I could do it as a
suggest,
floor amendment.
yes, if the bill gets out of committee, then get a floor amendment prepared to resolve Senator McClellan's issue.
Be happy to.
Move the report, Mr. Chairman.
Okay, we've got a motion to report. Is there a second? Got a motion and a second to report. Are there further motions or additional discussion?
Mr. Chairman, reluctantly,
Senator Bell.
Mr. Chairman, move to PBI. I think there's issues with the bill. I appreciate the patrons' hard work on this. But given the fact that we just passed the other law, the Supreme Court and other answers or other information on this, I think that this is not the time for these changes.
Okay, got a substitute motion to PBI. Is there a second? Got a substitute motion and a set to PBI that's been seconded. That's the motion we'll take up first. I'd ask the clerk to open the roll.
Senator House to abstain.
Senator Howell, let me get the 861 will make it 762.
Okay. Thank you, Delegate Levine. The next bill is Delegate Lopez. It's House Bill